ladies and gentlemen. I think we're ready to start. Firstly, thank you for joining us. My name is Thando Manenza, and I'm a partner in our CPL department. I am very well aware that you guys are not here to hear me speak the whole morning, so I'm going to be very brief. And I just want to just introduce our speakers and just give you a sense of what we're going to be discussing today. As you all know, Adams & Adams' primary objective is to form very strong and lasting partnerships with its clients in order to assist you all in navigating your business risks. Our country's labor laws are presently a highly contentious issue at the moment, and the laws are rather cumbersome, difficult to follow, and quite often difficult to understand. This is the primary motivation of organizing a seminar like this. It's to firstly to introduce you to the members of our labor team and to help you guys navigate these challenges. Today, our labor practice group will discuss some of the key major legislative enactments in this environment and how these changes may affect you and your businesses. We'd also like to take this opportunity to introduce you to the members of our labor law team. I think some of you have long relationship with Adams & Adams and might not be very well aware of some of the things that our labor law team can do. It's a relatively new team within the greater context of our service offerings. So I'd like this not just to be an opportunity to learn and understand these new laws and new changes in the regulatory environment, but to also meet and greet and discuss some of the other challenges that might be unique to your particular organizations. So without further ado, I just want to firstly just discuss, I think you've seen the agenda by the seat that you're sitting on. The first discussion is going to be by Shad Savant, who is the leader of the team. He's going to be discussing the new CCMA rules. Followed by him will be Aslam Patel, who will be discussing the very controversial, as you will all know, the National Minimum Wage Act and its regulations. Thereafter, Aslam will also then touch on the Basic Conditions of Employment Amendment Act. And then followed thereafter by Tandega, who will discuss the Labor Laws Amendment Act. To conclude the seminar today will be Ashad again, who will discuss the Labor Relations Amendment Act. Now, obviously, the aim of a discussion of this nature is to be short and punchy. There will be opportunity towards the end to ask any questions, but again, like I said earlier on, if there might be specific issues that aren't necessarily dealt with in this seminar that you want to discuss with our team members, please feel free to do so. Without further ado, I would like to welcome Ishad to the stand.
Thank you, Thando. As Thando mentioned, I'll be discussing the amendments to the CCMA rules. I'm only going to focus on the significant amendments to the CCMA rules. And as some academics have put it, most of the CCMA rules remain intact. What the drafters to the amendments to the rules have tried to achieve is to streamline certain processes within the CCMA and also to bring the rules in line with certain amendments to certain labor law amendments, certain recent labor law amendments. So that's basically the purpose of the CCMA rules. There's a list of the rules I'll go through, and I'll go through them in that order. The first rule I want to discuss is when must the Commission notify parties to conciliation? But firstly, what is conciliation? Conciliation, as many of you will know, is a process where the CCMA enrolls a matter for conciliation, which is really a meeting with the Commissioner and the parties, where the Commissioner tries very hard to settle a dispute. And the CCMA really has to be commended in this respect because it has a very high success rate in settling disputes. And its reputation in settling disputes has been recognized by many, including Judge Van Niekerk in a not too long ago article that he authored. Now, in terms of the old CCMA Rule 11, the CCMA had to notify parties at least 14 days before the conciliation process, unless the parties agreed to a shorter period or if reasonable circumstances permit for a shorter period. In terms of the amendment to the CCMA rules, at least 7 days notice need to be given where you are dealing with your mutual interest disputes, or which is more commonly known as your strike disputes or your lockout disputes, or a large-scale retrenchment dispute where a facilitator is not appointed. So at least 7 days notice must be given to the parties in those type of disputes. And in all other disputes, at least 14 days must be given. The exception to both of those instances is where reasonable circumstances would permit a shorter notice period, or where the parties agree to a shorter notice period. And that's basically the amendment to Rule 11. And then there's a new insertion, which is Rule 14A. This deals with the extension of the conciliation period. And it's quite a significant amendment in the sense that effectively, as some academics put it, it gives the CCMA 4 bites at the cherry in attempting to conciliate a dispute or to resolve a dispute. So if a party intends to request an extension of the conciliation process, that party, or in fact the conciliating commissioner, may request the director of the CCMA to extend the process by an extra 5 days. And that request must be made within 30 days from the date of receiving the referral at the CCMA. The factors that the director has to take into account are listed there. And one of the factors is whether reasonable prospects exist for reaching a settlement. The CCMA director would need to consider the request within 2 days upon receipt of the request, if the process will be extended. And the reason why some academics state that this effectively gives the CCMA 4 bites at the cherry is because pre-conciliation phase, in terms of the CCMA rules, the commissioner is entitled, or within his or her right, to pick up the telephone and contact the parties and try and settle the dispute. So that's the first bite. The second bite is at conciliation. The third bite now is if there is extension of the conciliation period. And the fourth bite is at arbitration, if the parties agree that the process can be converted to a conciliation period, then that's effectively the fourth bite at the cherry. Then the next rule is the conduct of CONARB in terms of section 191(5)(a), and in terms of the old Rule 17. In fact, before I discuss this rule, the Labour Relations Act requires certain disputes to be set down for CONARB. So what is a CONARB process? CONARB is basically conciliation and arbitration in one sitting. So for instance, you'll find many of your misconduct disputes and incapacity disputes are set down for CONARB. And where conciliation fails, immediately thereafter the arbitration will be set down on the same date in the same sitting, so to speak. So if a party intends to object to a CONARB process, the party may do so, but has to give at least 7 days notice to the CONARB, before the date that the CONARB is enrolled. And it's not competent for a party to object to a proceeding that is a dismissal dispute or an unfair labor practice dispute that relates to probation. But what the amendment has done is it has broadened that list, so to speak, and it has included now a dispute related to a compliance order in terms of section 69(5), and in terms of the amendment to the Basic Conditions of Employment Act. I'm not really going to discuss that provision at length. My colleague Aslam Patel will touch on that during his presentation. And also, it is also included a dispute for a claim for the failure to pay an amount in terms of Section 73A of the BCA. There is also an amendment to section to the Basic Conditions of Employment Act, and that basically deals with your your failure. Excuse me, your failure to pay an amount that is owed in terms of the Basic Conditions of Employment Act, or in terms of the National Minimum Wage Act, which my colleague Aslam will also touch on, or in terms of an employment contract, or a collective agreement, or a sectoral determination. So those disputes, even if you object, it has to sit for CONARB, and this basically accords with the purpose of the amendments of the rules. The purpose really is to try and streamline the process And we see that here when we come to certain processes that deal with time periods, and also to, as I've mentioned, to try and keep abreast with the amendments to the Labour Relations Act. Now, Rule 20 deals with con-arb processes. What is a con-arb process? A con-arb, a pre-arbitration conference. A pre-arbitration conference is really a meeting between the parties where they try and agree to settle or to try and narrow the issues in dispute. So they'll agree to what the common cause facts are, what the issues in dispute are, and in terms of the old Rule 20, the parties were not necessarily required to convene a pre-arbitration conference unless, of course, if they agreed to do so or if the CCMA directed the parties to do so. However, in terms of the amendment to Rule 20, the parties must hold a pre-arbitration conference at least 14 days prior to the date of the arbitration if both parties are represented by a trade union or employers organization or a legal practitioner or a candidate attorney, or if both parties agree to hold a pre-arbitration conference, or if directed to do so by the CCMA. And the referring party must file the pre-arbitration minute at least 7 days before the date of the arbitration. Now, Rule 25 is one of the more significant amendments to the CCMA rules. The old CCMA Rule 25 deals with who is entitled to represent a party at conciliation and at arbitration. Now, at conciliation, the party can appear in their own right at the conciliation process. They are not allowed to be legally represented at the conciliation. That has remained in terms of the amendment to Rule 25. In terms of the arbitration process, the same parties are entitled to represent themselves at the arbitration, which will include being represented by a trade union in the case of an employee or by an employer's organization. Legal representation is not an automatic right in terms of Rule 25 at the arbitration stage. However, if a party wishes to be legally represented, if the dispute relates to a misconduct dispute or an incapacity dispute, those type of dismissal disputes, then the commissioner, in terms of the old rule, would permit legal representation, provided that the commissioner was satisfied that certain requirements have been met. So if, for instance, the commissioner will have to determine whether questions of law or the nature of law, the complexity of law, the commissioner will have to determine the issue of public interest and the competitive ability of the parties. All of that remains in terms of the amendment to Rule 25. The change that now has been made is there's also been the CCMA has sought to broaden the type of disputes where if a party wishes to be legally represented, then the conciliating commissioner must also then decide whether it will be unreasonable to permit legal representation in those circumstances. So the disputes that have now been broadened in Rule 25 that do not automatically permit legal representation is a dispute in terms of Section 69(5), which is a compliance order, which I've touched on. Section 73, this is where a compliance order is sought to be made an arbitration award, which Islam will also deal with when he discusses those relevant amendments, and Section 73A, which is something that I've also touched on. What has also been clarified is that in a large-scale retrenchment facilitation, legal representation is not allowed, and it is there in the slide who is entitled to represent a party at a large-scale facilitation. Now, there has been a recent case in the bargaining council where this bargaining council, I think it was the MEIPC, this bargaining council followed the CCMA rules. Okay, so the bargaining council is kind of an equivalent to the CCMA, and here in the case of Coetzee versus Autohorse Centurion, one of the parties applied for legal representation, but took the point that in terms of Section 25 of the Legal Practice Act, it superseded Rule 25 in the sense that Section 25 allowed for legal practitioners, including candidate attorneys, to represent a party at any court or tribunal subject to any law. The commissioner agreed with that point and was of the view that his hands were tied, and it wasn't necessary to consider Section 25, Rule 25 in light of Section 25. Now, the CCMA was aghast at this ruling and recently issued a directive stating that it disagrees with this decision, and insofar as the CCMA is concerned, a party still has to apply for legal representation in terms of Rule 25. And what's motivated this rationale of the CCMA is that the CCMA has stated that to the extent that there is any inconsistency with the Labour Relations Act and any other law, the Labour Relations Act prevails. So it's still uncertain terrain. Over time, we'll see how litigation pans out, and no doubt there will be more cases of this nature, and I think it probably will go all the way to the Constitutional Court eventually. And then Rule 29 deals with disclosure of information. In terms of the old Rule 29, a party or the CCMA commissioner could make a ruling in relation to the relevance or discovery of documents any time before the finalization of an arbitration. However, in terms of the new Rule 29, a party is required to, if the party wishes to request discovery or wishes to request the disclosure of relevant information, this party must do so at least 14 days prior to the date of arbitration. If the request is made, then the party receiving the request has 5 days within which to respond to that request. That's basically Rule 29. And then the last two rules I just quickly want to touch on is Rule 31A and Rule 31B. Now, Rule 31A deals with the picketing rules, and the aim here is to try to have a very quick process where a dispute is referred to the CCMA to deal with picketing rules, and this is really to align itself with the amendments to the Labour Relations Act dealing with picketing rules, and that's something I will touch on when I discuss the amendments to the Labour Relations Act. And so it's a very quick process that is envisaged there in terms of Rule 31A, and in terms of Rule 31B, this is where, as I understand it, an application is made to make a written undertaking or compliance order to be made an arbitration award. There also the process is set out. There's time periods that have to be complied with, and it's quite stringent or quick time periods. And those are basically all the rules I want to touch on insofar as the CCMA is concerned. Thank you.
Thank you very much, Shad. I think we all agree that quite often disputes in the labor context play themselves out in the CCMA, and it becomes quite a very important forum for us to understand and how to deal with and how to navigate our way through those regulatory processes. What I took a lot, which is interesting from Shad's discussion, is how an infringement of some of the legislation that we'll be discussing today is going to probably play itself out more in the CCMA, which is quite an important thing to understand. Okay, so moving along, next we're going to have Aslam Patel. Aslam is going to discuss the highly controversial National Minimum Wage Act and regulations there. Okay, stop.
Good morning, ladies and gentlemen. I trust that you are all doing well this fine morning. Thank you, Tando, for the introduction. As Tando mentioned, I'm going to be discussing the highly controversial but historic National Minimum Wage Act. I am sure that over the last 3 to 4 years, the majority of you have read newspaper clippings and various social media postings, which on one hand has criticized the National Minimum Wage Act and the implications that it might or may not have insofar as our economy is concerned. And on the other hand, disgruntled employees complaining that the actual current National Minimum Wage Act of 20 Rand per hour is actually not a living wage. Be that as it may, in November 2018, Cyril Ramaphosa introduced and signed the National Minimum Wage Act into law. That law came into effect on 1 January 2019. Accordingly, as of 1 January 2019, every employee employed in South Africa cannot be paid less than a national minimum wage. It is the first time in our history that minimum wages are regulated at a national level. Prior to the enactment of the National Minimum Wage Act, wages were generally managed and regulated in terms of sectorial determinations, which are sector and area specific. Those were issued in terms of the Basic Conditions of Employment Act. And furthermore, wages were regulated in terms of collective bargaining agreements that are concluded in terms of the Labor Relations Act. However, with that in mind, Minister Mildred Olivier, who was the Minister of Labor at the time, stated the following in April 2018. The enactment of the National Minimum Wage Act at its current rate of 20 Rand is set to benefit approximately 6.6 million workers, out of whom 4.4 million workers earn below the current minimum wage in terms of a sectorial determination which was issued in terms of a Basic Conditions of Employment Act. Furthermore, 2.2 million workers who are unorganized, whose wages were not regulated in terms of any collective bargaining or did not form part of any trade union, also earn below the current National Minimum Wage Act. Furthermore, on the other hand, the Free Market Foundation is of the view that the creation of a national minimum floor wage is an act of economic insanity which threatens to turn an already untenable employment situation into a total calamity. To place both of these comments into perspective, our current population is sitting at approximately 57 million. Our current workforce is approximately 16 million, and our current employment rate is currently sitting at approximately 27%. And if discouraged work seekers are taken into account, that rate increases to 36%. Furthermore, to put those numbers into perspective, approximately 25 to 30% of our of our population earns below the upper band of the poverty line, which is approximately 1,250 Rand per month. And a further 12 million people earn below the lower poverty line, which is currently 540 Rand a month. What are these poverty lines? These poverty lines are the amount of calorie intake that a human being needs to survive. But be that as it may, the National Minimum Wage Act is in law, and all employees as of 1 January need to comply with it. Insofar as the framework and structure of the National Minimum Wage Act is concerned, sorry, I tend to forget to move my slides at time, please excuse me on that, but we will send copies of these slides to you via email as well. So the framework and structure of the National Minimum Wage Act. The Act in itself deals with the application, applicability, and the amendment procedures insofar as the rise in the minimum wage is concerned. The exemption process for an employer who cannot afford the minimum wage is dealt with in terms of the regulations to the National Minimum Wage Act. And the enforcement and fines for employees who do not comply with the National Minimum Wage Act is dealt with in the Basic Conditions of Employment Amendment Act. Now, one of the most significant amendments to the National Minimum Wage Act is who it applies to. Generally or traditionally, the employment framework insofar as regulations are concerned required an employer and employee relationship. And currently, if you look at the definition of employee in terms of the Basic Conditions of Employment Act, it specifically excludes independent contractors. But what actually has been done in terms of the National Minimum Wage Act is that it applies to all workers. And based on the current definition, it is possible that it could include independent contractors insofar as they are self-employed or individual or own workers. What this creates is a situation where you have somebody that potentially comes into your business on not a regular ordinary hour worker. He could possibly come in 3 times a week or 3 times a month or 3 times a year. He comes in, does what he required to do, maybe clean a window for you or maybe provide some advisory services. That employee or worker is now protected in terms of the National Minimum Wage Act, and he needs to be paid at least the national minimum wage. You cannot pay him less than that amount, and he can refer disputes to the CCMA insofar as it's concerned. On the other hand, it is defensible that it doesn't apply to independent contractors, because if you look at the definition, it says means any person who works for another. By the legislature excluding the word means any person who performs work or works for the other, it's arguable that it does not apply to independent contractors. However, by the move from the legislature to move from the traditional meaning of employee to worker, it is, as it stands currently, also applies to independent contractors who are self-employed. That widens the scope of who is protected in terms of the National Minimum Wage Act. Exclusions: the National Minimum Wage Act doesn't apply to any members of the South African National Defence Force, National Intelligence Associations, the South African Secret Services, and volunteers. Now, if you look at Section 4, read with Schedule 1, that is where the National Minimum Wage amount is set. It's currently at 20 Rand per hour. Now, it's common in government that the 20 Rand an hour isn't actually a livable wage. But be that as it may, they have now provided for provisions as well that will allow this wage to be increased annually, as I'll discuss as we move on to the presentation. The National Minimum Wage Act, I'll be dealing with this slide and the slide on the calculation of the wage simultaneously. Now, the 20 Rand an hour is for all employees who are below the national minimum wage or workers. Now, if you work a 40 to 45 hour week, because the National Minimum Wage Act, as will become clear, is applicable to ordinary hours of work, which is a 40 to 45 or a lesser amount of hours that you work. And it is not applicable to your overtime. It's not applicable if you are required to work on a Sunday, or that obviously would have its own rules and regulations that apply to in terms of the peak day. You have to pay 1.5 times over the rate. So if it's a normal 40-hour week, it roughly translates to 3,600 Rand a month. If it's a 45-hour week, 3,900 Rand a month. Now, the legislature has provided for certain exemptions, certain categories of employees who are exempted from the 20 Rand per hour national minimum wage. These are currently the farm workers and domestic workers. However, as these two categories of employees are concerned, it's more of a transitional or phase-in exclusion or exemption. Because within 2 years of enactment of this act, these workers would have to be brought up to at least close as possible to the minimum wage or to the minimum wage itself at the time it should be. So they would remain currently for approximately about 2 years at the current rate, which would then increase to what the national minimum wage is within 2 years. Insofar as workers in the expanded public sector work program is concerned, their national minimum wage is currently 11 Rand. This will obviously increase as the national minimum wage increases yearly. It will increase proportionately to what the national minimum wage increases. Learners who have concluded learnership agreements are entitled to specific allowances. Those are regulated in terms of Schedule 2. Those allowances are dependent on the NQF level and the credits earned. The Act is silent insofar as how those will be amended and whether they would be amended proportionately to the National Minimum Wage Act. Now, the calculation of the National Minimum Wage Act depends on the ordinary hours. It's calculated on your general ordinary hours. Now, interesting is Section 9, which deals with ordinary hours of work, which is, if it's a five-day week, approximately 40 hours, and if it's a 6-day week, 45 hours. But in terms of Section 9A of the BCEA, it's a new section that's been included, which mentions that if you have an employee who works for you less than 4 hours a week, and he earns below the current threshold, which is 205,433.30 per annum, that employee, if he works less than 4 hours on any given day, or he regularly works less than 4 hours, would need to be paid at least the minimum wage for 4 hours of work. So if you have somebody that comes in, works 2 hours, and leaves every day, he needs to be paid for 4 hours of work as opposed to just the 2 hours of work. Excluded in that amount of the calculation for the national minimum wage is that you cannot per se, for example, if you're paying your workers at the national minimum wage amount per hour, it's the take home per se amount of money. Included in that is not any allowances. You can't go to an employee and say, okay, you're earning the national minimum wage, 20 Rand an hour, but in there I gave you some food, 5 Rand, I gave you a transport allowance, another 5 Rand. So in effect, he's walking home with about 10 Rand. That's not allowed. It excludes all allowances that will enable an employee to do his work. Any payment in kind, bonuses, gifts, and so forth are also excluded from the national minimum wage calculation. However, generally, UIF payments and so forth will obviously be able to be deducted from the national minimum wage. Most importantly, the sections 4 subsection 6 to 4 subsection 8. What this does, it creates a right. Every employee has a right, or is entitled to earn a wage that is not less than the national minimum wage. It's now become a right. And every employer is obliged to pay an employee not less than the minimum wage. Now, what then it says further is that in terms of section 4 subsection 6, if you have an employment contract, or yourself and an employee agree that it's fine, we understand the national minimum wage is 20 Rand, but it's fine, you can pay me 15 Rand an hour. That is not allowed, and it can be enforced. The national minimum wage will then be enforced when we respect of the agreement. It can never be waived. And it takes precedence over any agreement, contract, collective agreement, or secretarial determination, which at the date that the minimum wage was enacted is lower than the national minimum wage. So any agreement that you have, null and void, it is below minimum wage, needs to be brought up to at least the national minimum wage. Insofar as you have employees who were earning below the national minimum wage, their contracts need to be amended, and mention needs to be made in those contracts in relation to the national minimum wage. So if you have these contracts, minimum employees earning below the minimum wage, those contracts need to be amended, and we suggest that that be done as soon as possible. And insofar as you intend paying employees the national minimum wage, but you want to go around it in that employees are earning below the national minimum wage, but are working an 8-hour day. So you bring it up to 20 Rand an hour. But what you then want to do is, you tell the employee, okay, fine, we pay you the 20 Rand an hour, but I only require you to work 5 hours a day, or 6 hours a day. So effectively, you'll be paying the same rate that you are paying him an hour on a daily basis, but you are reducing his hours to give effect to what the national minimum wage is. Now, that is an unfair labor practice. It is not allowed, and a dispute can be referred insofar as unfair labor practice is concerned. There is some controversy around this section because a unilateral change, this is without his consent, by making it an unfair labor practice, does it limit the right to strike in terms of section 64.4? Because in terms of section 64.4 of the Labor Relations Act, an employee whose contract of employment has been unilaterally amended has a right to strike. But now by making it an unfair labor practice, does it mean that he needs to first approach the CCMA before striking? Or can he refer an interest dispute and then strike based on that? So it will all depend on how an employee actually words that dispute, and let's see how it pans out as we go along. Insofar as the annual review is concerned, because the national minimum wage currently is 20 Rand, government accepts that it's not a livable wage. There is provisions in the Act for the Commission on a yearly basis to review that national minimum wage, and then present recommendations to the Minister of Labour on any increases or whether they should remain the same, and those increases will then be implemented in terms of what government presents. So the national minimum wage will increase. I highly doubt it's ever going to decrease, and it's here to stay, and people need to comply with it. Now, insofar as employers cannot comply or afford with the national minimum wage, there's some good news. In terms of Section 15, you can apply for an exemption. An employer or employees organization can apply for an exemption for the national minimum wage. That's the good news. However, I'll be dealing with these two slides interchangeably. The bad news is that the biggest discount you would receive is 10%. You're not going to be getting more than 10%. So, good news, you can apply for an exemption. Bad news, the highest discount you'll get is 10%. Now, how do you apply for this exemption? I see we're moving with the times that now it's more so a online process, paperless. But beware of navigating the website. Shutdown times, downtimes, websites having issues. And you need to go onto the website, Department of Labor website. There's an icon in relation to the national minimum wage exemption system. You register on the system. And before considering any application for exemption, the only reason upon which an exemption will be granted is if an employer can truly, and I mean truly, not afford a national minimum wage. And in order to assess whether an employer can afford this national minimum wage, the profitability, liquidity, and solvency test will be applied. And you need to submit, together with an application, a 3 years financial statements. And together with that, you need to have consulted meaningfully with the trade union and all the employees to explain to them and say that this is our position. We can't pay you the national minimum wage of 20 rand per hour for these reasons. We can't afford it. We're going to have to go through potential retrenchments. Our businesses will suffer, so forth. So we have to consult with them. Then you need to obviously provide a copy of your application once it's completed on the website, download it, and provide a copy to the affected workers and employees, as well as you need to show and provide proof that you have complied with your statutory obligations. Once these requirements are met, you will qualify for your 10% discount. Now, 10% in the larger scheme of things might not seem much, but if you're an employer that employs 2,000, 3,000 employees, 10% of an hourly rate is 2 rand. Times 9 hours a day or 8 hours is 16 rand. It adds up. So you need to comply with the minimum wage if you do not have an exemption. Pending the outcome of an exemption application, you still need to be paying the minimum wage. And the issues then come in is once you've been granted this exemption and you can still not afford paying your current amount, what do you do? And that's the point where you need to then get further legal advice. There are other alternatives. Do we now try to get employees to be working shorter periods of time? Do we want to implement shift systems? And that's where you need to get the legal advice on how to get that those methods in place. Now, an exemption will only be granted for 1 year. So every year you need to apply for a new exemption if you can't afford it based on the new set of financial statements. Insofar as the withdrawal of an exemption is concerned, an exemption can be withdrawn under certain circumstances. If the employer has lied in the application for an exemption, if the employer has not complied with the exemption notice, if the employer's financial situation is improved. Now, other justifiable grounds. Currently, a few months ago, there was an employer who was granted an exemption following the proper processes. However, that exemption application was withdrawn, and currently the Department of Labor is considering instituting a fraud action against this employer. What the employer did was, he was granted the actual maximum 10%, but he took the notice and he amended it to 16 rand as opposed to 18 rand. And he provided the amended notice to his employer. So that application will be withdrawn, will then be required to pay the 20 rand and possibly face fraud charges. Now we will deal with the basic conditions of the Employment Amendment Act. Most of the amendments in terms of the basic conditions of Employment Act are to give effect to the National Minimum Wage Act. What it has done is that it is trying to streamline the process insofar as enforcement and compliance is concerned. It's made it easier and more cost-effective for the employee actually to refer a complaint to the Department of Labor. And it also has a more streamlined process where the employee can actually go directly to the CCMA as opposed to the Department of Labor. Now, prior to dealing with those, the other two amendments to this are also in not so far as they deal with the exemptions, but as I mentioned earlier, is the 4-hour workday. If you're working less than 4 hours, you need to pay the employee for 4 hours. And secondly, the secretarial determinations. Now, any secretarial determination that is in place that is higher than the national minimum wage, those secretarial determinations will increase proportionately as and when the national minimum wage increases. So if you have a secretarial determination where you're bound to pay an employee 25 Rand an hour, that secretarial determination will remain in place. It won't be repealed insofar as the remuneration portion is concerned, but it would increase as and when the national minimum wage increases. Now, the chapter that deals with the enforcement is Chapter 10. Chapter 10 also includes a definition of worker as discussed. So it is possible that independent contractors or own workers can access, can actually use the enforcement processes that I mentioned here. Now, before the amendments and before the enactment of the National Minimum Wage Act, labor inspectors had certain functions. One of them was to assist an employer and employee in fulfilling their duties, conducting inspections, conducting investigations, and so forth. Now, however, there are additional duties and responsibilities that they have. One is they may refer a dispute to the CCMA if you fail to comply. And the second is that they may act on behalf of the Director General at any proceedings. Now, when you're looking at the enforcement proceedings, if you do not comply and you haven't been granted an exemption, or you haven't bothered getting an exemption but you still do not comply with the minimum wage, the labor inspector and employee could then contact the Department of Labor. And on Workers' Day this year, the President launched a whistleblowers hotline where it's called Impimpi Alive. Employers or employees can actually send an SMS, anonymous SMS, directly to the Department of Labor, saying that I work at so-and-so place, the address is so-and-so, and I'm earning below the national minimum wage. And within 48 hours, a labor inspector would be dispatched at your premises. Now, the first process is once the Department of Labor receives a complaint, they will conduct an investigation, and if they reasonably believe that you have not complied, then they can either offer you a written undertaking or issue a compliance order. Now, if you do not comply with a written undertaking, no longer is it an issue that it needs to go to the labor court to be made an order of court. They can go directly to the CCMA and get the undertaking to make an arbitration award. And it doesn't seem like it's going to be a procedure where you'd be afforded an opportunity to make a hearing. Same with the compliance order. If you do not comply with the compliance order, you would then, the Labor Department would obviously approach the CCMA. And the CCMA just needs to satisfy himself that, listen, one, the employer has received the compliance notice, it was served on him, and he hasn't referred a dispute to the CCMA. If it meets those two requirements, the arbitration, the compliance order will be made in arbitration. Obviously, these are subject to reviewing the decision rules on the apply. Now, insofar as the second approach is concerned, they can skip the entire route of referring it to or complaining directly to the Labor Department. The employee now can approach the CCMA directly. He can make a referral directly to the CCMA. Now, just going back on the compliance orders and written undertakings. A compliance order, once you receive a compliance order, an employer, prior to the date where, in terms of the compliance order where he is required to comply, can dispute the compliance order at the CCMA. So if you receive a compliance order, you are not happy as to one, I think I have complied, and you are wrong in issuing with the compliance order. Or two, that I think that the compliance order that you issued to me is the fine in it or the certain requirements that I don't agree with. Then you as an employer can challenge it at the CCMA. At that forum, you're not going to go and say, I can't afford it. The affordment part, and whether you can afford it or not, is dealt with the exemption process. At this point, is just if you are disgruntled at the order for some reason, the compliance order that I'm not happy at the fine that I've been paid. Oh wait, this compliance order has been issued wrongfully. I actually comply. But the onus of proof in any proceedings, insofar as non-compliance with the National Minimum Wage Act or the BCA is concerned, lies on the employer. All the employee needs to do is complain. When the Labour Department visits you or you follow the CCMA route, the onus would lie on you as the employer to prove that I have a record. I've said so here's my record. I've been paying people about the minimum wage. I've been providing them with the minimum requirements. You need to prove that that record is valid and accurate. If you don't have a record, you're going to prove that you have complied. So the onus lies on you to prove whether you have complied with the National Minimum Wage Act or the Basic Conditions of Employment Act. We've discussed that compliance orders may be made in arbitration award and what requirements need to be met. Just on that topic again, it's from the reading of the Act and what is required, it doesn't seem like it's going to be a full-out hearing. As long as you have received the compliance order and you haven't referred a dispute that interrupts the compliance order, it's going to be made in arbitration award, and you need to comply with arbitration award, obviously subject to the rules of you reviewing it at the labor court or rescinding it. Now, insofar as the CCMA proceedings that are concerned in relation to non-compliance, legal representation are allowed. You can have legal representation insofar as any disputes are concerned in relation to the BCA, underpayments, and non-compliance with the national minimum wage. Now, a labor inspector under certain circumstances cannot issue a compliance order. That's if the employee who complains earns above the threshold, which is 205,433 Rand, or the employee has followed the route of excluding the Department of Labor in its entirety and went to CCMA route. Under those circumstances, the labor inspector cannot issue you with a compliance order. Furthermore, and this I think is important, and we're only coming to play, obviously, we will actually see the benefits of this later as the Act progresses, is that if the amount claimed has been owed for longer than 36 months from the date on which the complaint was made. So if an employee has complained and 36 months has lapsed and the Department of Labor has not done anything, they cannot issue with the compliance order. Or 36 months after the Labor Department has granted you an undertaking. So if they have not done anything for 36 months, which I think is very unlikely. Previously it was 12 months, it's now going to 36 months. Under those circumstances, then it seems like whether it would lapse, it would seem, but whether the employee can approach other forums, the labor court, high court, so forth, to institute his rights remains to be seen. Now, we've discussed the claim where you can approach the CCMA directly now, and that is only available to employees who earn below the threshold. So if an employee that earns below the threshold, 205,433.30, you may approach the CCMA as opposed to the Department of Labor. We have another route available, the employees have another route available, and that is they can also approach the Labor Court, High Court, Merge Court, also Small Claims Court. Now, the fines. If you do not pay or do not comply, the fines are pretty hefty though. If you have a workforce of 1,000 people, and all of those 1,000 people are paid below the minimum wage, in addition to your compliance order, you're going to have a fine. The fine is the greater of twice the value of the underpayment. So if it's 5 Rand, 5 times 10 Rand times 1,000 people, or twice the employee's monthly salary. So that's the fine. The fine is hefty, and that's just for a first offense. For a second offense, the fine increases to 3 times the value of the underpayment and 3 times the employee's monthly wage, whichever is greater. But what's also interesting now is that the department is required to maintain and publish a list that will be updated quarterly of employees that have been issued with compliance orders, and this list will be publicly accessible. And this could have reputational damage for a company. A company could be precluded from conducting businesses with government. A party could be precluded from, it could actually be a red flag in a DD. that the company hasn't been complying with the minimum wage requirements and the BCAA requirements. So they taking it quite seriously. Apart from the hefty fines, the easier enforcement processes, they're going to be publishing and naming and shaming people, and it's important that we try to comply, and if we don't, try to seek those exemptions, and then if it still doesn't work out, seek legal advice on alternatives on the way forward. Just on a lighter note, if you think the minimum wage is a very high amount, if these charge the minimum wage for production of honey, a jar of honey could cost us in the region of 900 to 1 million rand. Well, that amount of hours they put in to produce the honey. Proof of compliance orders we've dealt with. Insofar as payments of interest is concerned, on any outstanding amounts, the Act makes provision for the payment of interest on it. So if you have been given a compliance order with a fine to pay by a certain date, every month if you don't pay the fine, obviously the interest accumulates on it at 10.5% per annum. And that's my presentation. Hopefully we can all start complying, and if we can't, do the necessary in getting an exemption. Thank you. Thank you.
Thank you very much, Aslam. That was very educational. There's no doubt in my mind that there's going to be significant case law in this, court challenges on this legislation. I mean, the affordability aspects, the independent contract aspects, and the parts where you're not really afforded a hearing with undertakings or compliance orders, in my mind, is problematic. I think from our team's perspective, we'll definitely follow the progress and the developments in this area of the law, and we'll update you guys accordingly should there be any new developments with cases. All right, then next we're going to have Thandeka Mhlongo. She will be discussing the Labor Laws Amendment Act.
Can somebody use this? Can you use this? Good morning, ladies and gentlemen. Can you just reduce this? I need to stand a bit higher. Thank you. Yes, that's better. My name is Thandeka Mhlongo, as Thando has mentioned, and I will be discussing the Labor Laws Amendments Act. On the 25th of November 2015, a draft bill was proposed in the Government Gazette which aims to amend the Basic Conditions of Employment Act as well as the Unemployment Insurance Act. Now, this amendment introduces adoption leave, parental leave, and commissioning parental leave as leave entitlements for parents who are also employees. The amendments or the bill comes just at the heel of the Labour Court's decision in the MIA versus State Information Technology Agency case, where an employee referred a matter to the Labour Court where they were requesting that the Labour Court declare that the employer's failure to provide the employee with paid maternity leave be declared an unfair discrimination on grounds of sexual orientation, gender, as well as family responsibility. Now, in this case, the Labour Court held that the rights to maternity leave as created by the Basic Conditions of Employment Act is an entitlement that is linked not solely to the welfare and health care of the child as the child's mother, but also connected to the child's best interest. The court went further to state that in order for us to properly address the paternity issues in South Africa, legislation as well as the Basic Conditions of Employment Act will need to be amended in order to safeguard the protections which are afforded by our Civil Unions Act as well as the Children's Act. Now, the Labour Law Amendment Bill was a private bill which was introduced by the African Christian Democratic Party in Parliament in 2015. It was a very welcome labor law amendment because it introduced new forms of leave which the Basic Conditions of Employment Act did not provide for. As we all know, the Basic Conditions of Employment Act only provides for maternity leave, which allows the maternal parents of the newly born child to take 4 consecutive months to take care and to bond with the child. And then the other parents will have to take 3 days family responsibility leave, or if they want to spend more time with their children, they'll have to take unpaid leave, or they'll have to take from their own annual leave in order to take care of the child. Now, this act now introduces parental leave as Section 25 of the Act and Section 25A of the Act, and it introduces adoption leave as Section 25B of the Act, and it introduces commissioning parental leave as Section 25C of the Act. The Act has been signed into law and been passed by the President. However, it has not come into effect yet, and it will come into effect on the date that is still going to be determined by the President. Now, when the drafters were drafting this act, they realized that our family structures have moved from the atypical family structures where the father is regarded as the breadwinner and the mother is regarded as the caregiver of the family. Now, our new modern structures, we find that the employees who are parents have a shared parental and earnings responsibility towards the newly born child. Now, the purpose of this act is therefore to accommodate these employees' dual roles as an employee as well as a caregiver, and to eradicate these gender assumptions that it's only the mother that takes care of the child and the father is the maternal, is a primary breadwinner. And in this day and age, we always see as well, we always have single mothers who also take care of the child and also takes care of the family as well. And as well with fathers, they also have single fathers who take care of the family, and they're also the primary caregivers of the mother, of the child. So Section 25A provides as follows. It states that an employee that is a parent of a child is entitled to at least 10 consecutive days parental leave from the date that the child is born, or from the date that the adoption order is granted, or the date in which the child is placed in the care of the prospective adoptive parents. Now, this will generally work out to 8 working days if the employee is employed for 5 working days, and it will work out to 9 working days if the employee is employed for 6 days. The one significant thing about this act, it's actually not clear, because it states that a parent of a child is entitled to take these leave days. So now the question here is, now, does the maternal mother who's entitled to the maternity leave also entitled to the parental leave? The act is unclear in that perspective, but when you look at the memorandum which actually laid out the objectives of this act, it states that the parent who's not entitled to maternity leave is entitled to the 10 days parental leave. So this can always be used as a guideline by employers when they're deciding whether to grant this form of leave to the maternal parent as well. Now, the employee must provide the employer with at least 1 month's notice before the child is born, or the child is expected to be born, or the date in which the adoption order is granted, or before the child is placed in the prospective care of the adoptive parents. If you can't do this, you need to provide a notice as soon as reasonably possible. So the parental leave, as I've mentioned, as you can see, it's a gender neutral leave. It can be taken by either the mother, it can be taken either by the father, depending on the circumstances of the particular case. Section 25B now deals with adoption leave. Adoption leave states that an adopted parent of a child who's below the age of 2 is entitled to adoption leave of at least 10 consecutive weeks, or parental leave, as I've mentioned previously. Now, in these instances, if an adoption order states that there are 2 adoptive parents, one parent is entitled to the adoptive leave and the other parent can exercise the parental leave in order to bond with the newly born child. Now, the purpose of this section is to provide the parent of the adoptive child with enough time needed for the adopted child to be able to adapt to this new environment. As you can see, it's capped to 2 years of age, because if a child is over the age of 2, we will assume that the child is now going to school, and you wouldn't actually need that much time to be able to bond, or for the child to be able to adapt to this new environment. However, if the parent is adopting a child that is over the age of 2, you could always rely on the parental leave to take care and bond with the new child. Now, an employee who's taking adoptive leave must provide the employer with at least 1 month's notice before the child is placed for adoption in terms of the adoption order, or as soon as reasonably practical. Now, the adoption leave will start from the date in which the legislative date of birth of the child, which is the date in which the order has been granted, or the date in which the child has been placed into the care of the prospective adoptive parents. Now, one of the provisos that are provided by the Act is that only one parent, as I mentioned, can use the adoptive leave, and the other parent has to use the parental leave. Now, it leaves it to the parents to decide who is going to take which leave, and it leaves it to the parents as well to be honest with the employers that I'm taking this kind of leave and my other partner is just taking this type of leave. And Section 25C then provides for commissioning parental leave. Now, in the new days and times, we have medical advancements where our reproductive technologies have advanced so much that a parent can now commission the birth of a child through a surrogacy motherhood agreement. Now, a surrogacy motherhood agreement is regulated by the Children's Act, and basically what it is that a surrogacy mother and the commissioning parents enter into a surrogate motherhood agreement wherein the surrogate mother agrees that she will be artificially fertilized for the purposes of bearing a child, and also undertakes that she will hand over the child on the date of the birth of the child or as soon as reasonably possible. Now, this Act now provides that an employee that is a commissioning parent in a surrogate motherhood agreement is entitled to commissioning parental leave of at least 10 weeks consecutively, or the parental leave. Now, as I mentioned again, if there's two commissioning parents, the one is entitled to the Section 25C leave and the other one is entitled to the parental leave. And it leaves it to the parents again to determine which parent is going to take the type of leave, and they must be honest to the employers and disclose that I'm taking this leave and the other parent is taking the parental leave. The one thing that this section doesn't mention is what happens then to the rights of the maternal mother. The maternal mother is also an employee somewhere. So now, is this maternal mother supposed to take commissioning parental leave, or is supposed to take parental leave, or is it supposed to take maternity leave? But then another thing is that it doesn't exclude the surrogate mother from taking the maternity benefits which are provided for by the Basic Conditions of Employment Act. Now, the parent, although the mother is not nurturing, the surrogate mother is not nurturing the child after the birth of the child, because she will be handing it over to the commissioning parents, she will be entitled to at least 6 weeks maternity leave from the date in which the child is born, or unless the medical practitioner or the midwife says that the surrogate mother now is fit to return to work. Now, as we all know, these forms of leave, as well as maternity leave, are all unpaid leave. Some employers are very gracious and they provide for paid maternity leave during the period that the mother is away for the 4 months. So, if the maternity leave is not paid at work, the employee can always claim it against the UIF in terms of the Unemployment Insurance Act. Now, in order to claim against the fund, you obviously have to be a contributor towards the fund. And if an employer has a policy in terms of which it pays an employee maternal benefits at the time in which the employee is sitting at home, then the same or similar policy should also be adopted for these parents who will be taking the new forms of leave. This is just to avoid employees referring unfair labor practice disputes to the CCMA, claiming that the employer is not providing same and or similar benefits to these parents who are taking the new form of leave. According to the Unemployment Insurance Act, it states that in order for you to be able to claim against the Unemployment Insurance Fund, you have to be a contributor, and you must at least be in employment for at least 13 weeks before you bring an application for these forms of benefits, parental benefits. Secondly, the UIF benefit is capped at 66% of the earnings of the parent, and it is at the maximum income threshold, which is set by the minister, and it's currently 17,712. Sorry for the math. But it's set at that currently. So if you're earning above that, then you will have to obviously accommodate yourself for the amount above 17,712 rands. Yeah. So the effect of this act, basically, it will be to repeal Section 27(2)(a) of the Basic Conditions of Employment Act, which allows, currently Section 27.2a provides for family responsibility leave of 3 days. So this act now is going to repeal the family responsibility leave for purposes of the parent to take leave for the birth of a new child. So now you'll only be entitled to adoption leave or parental leave or commissioning parental leave. However, you still will be entitled to the other forms of the 3 days leave if your child is sick or if there's a death of a spouse or a death of your child. You'll still be entitled to those 3 days paid family responsibility leave. As I had mentioned, this act hasn't come into effect yet. And maybe one of the reasons that it has not come into effect is because the UIF is still gearing up its systems to take these claims from the new parents now who are going to be claiming for this type of leave. However, now, the fact that this act hasn't come into force yet doesn't mean that it's not going to come into force. So as employers, we need to now start changing our systems. If we have employment contracts that provide for maternity leave and they say that these are the types of leaves that you're entitled to, as employers we need to start changing them now. If there's also a policy that's also regulating leave entitlements in the workplace, we need to start implementing them so that when the act comes into force, we are in compliance with the Basic Conditions of Employment Act. We cannot contract out of them. We cannot contract out of the Basic Conditions of Employment Act, and we still can't contract out of these leave entitlements that are provided by this act. So if Adams and Adams, we are here to assist you. We'll be in your hands to assist you in amending any of employment contracts as well as the policies in order for you to ensure that you're in line with the Basic Conditions of Employment Act when this act comes into force. Thank you so much.
Thank you very much, Thandeka. Another very educational talk. So moving right along, the last speaker for today is going to be Ishad again, and he's going to be discussing the amendments to the Labor Relations Act.
Thanks again, Thando. Okay, so the amendments to the Labor Relations Act, they mainly relate to collective bargaining. In particular, your picketing rules, the extension of collective agreements concluded in bargaining councils, and the right to strike to some extent. In terms of the old Section 32, it's a very technical section. It details the requirements that must be met before a collective agreement that has been concluded in a bargaining council is extended to non-parties. But firstly, what is a collective agreement? A collective agreement is an agreement between, on the one hand, a trade union or trade unions, and on the other hand, an employer or employer organizations. In the context of a bargaining council, which as I mentioned previously, is kind of the equivalent of the CCMA. The parties ordinarily the collective agreements would be concluded in a bargaining council, and where they seek to extend the collective agreement to non-parties, which really tries to give effect to orderly collective bargaining. The requirements in terms of Section 32 has to be met. So there have been some changes. I don't intend to bore you with all of the changes because, as I've said, it's very technical. But I think just for purposes of appreciating one or two of the amendments, I'll go through maybe one or two of the requirements that have to be met in terms of the old Section 32. So in terms of the old Section 32, where the majority of the parties agree that the agreement should be extended, it has to go through this process where the bargaining council requests the minister to extend the collective agreement to non-parties. Now, the minister's function is still in place. The minister is still responsible for extending the agreement. There has to at least be the majority of employees to whom the agreement will apply. They need to be members of trade unions who are members of the bargaining council, and they need to be employed by employers who are members to employer organizations that are party to the bargaining council. So that's in terms of the old act. In terms of the new act, either or requirement will suffice. In fact, it goes a step further. Where none of those requirements are met, the agreement can still be extended where the parties are sufficiently representative. Now, the Section 32 in its current form and in its new form does go into some detail about what constitutes sufficiently representative. Some of the other provisions that have changed in terms of Section 32 is that the function that would have been performed by the Minister of Labour is now transferred. Those functions have been transferred to the Registrar of the Labour Court to perform. The Minister, as I say, would still extend the agreement, but will be exercising more of a rubber stamp kind of duty. So those are some of your amendments in terms of Section 32. Then we come to the provisions that deal with picketing in terms of Section 69. Now, much of this also hasn't changed. Section 69 deals with your picketing rules, and a trade union may authorize a picket in support of a protected strike or any lockout. Your picketing rules really will contain information about the conduct of the picketers, the timing of the picket, and so forth. Now, these rules, in terms of the old, the section in terms of the old form, it's clear from the old Section 69 that it is envisaged that there must be picketing rules. However, it is clarified now in terms of the amendment that before a picket takes place, the rules have to be in place. So there are more strict time periods. So the aim really is to try and regulate the timing of the picketing rules. The intention in terms of the new Section 69 is that there must be picketing rules before a picket takes place. And what's envisaged here is that there'll be a referral to the CCMA and the Commissioner. If there are no picketing rules that have been agreed, for instance, in a collective agreement, then the conciliating Commissioner must determine picketing rules, and that determination must be done, I would say generally within 30 days, because it's the time period that a certificate of outcome is issued, and a certificate of outcome is issued after conciliation, which generally is within 30 days. So that's your Section 69 that deals with picketing, and quite a significant amendment has been the amendments to, or rather the insertions of Sections 150 to 150D, and these amendments really try to give effect to an advisory arbitration panel. So it's the establishment of an advisory arbitration panel. It deals with the function of the panel and the effect of an arbitration advisory award that is issued. The idea here is for the director of the CCMA to convene an arbitration panel where the director is of the view that a dispute, and in this context we're dealing with a strike dispute, where a strike dispute or lockout has become so prolonged that it seems unlikely that it will imminently resolve, or where the strike is likely to turn violent or has already turned violent, then the director can kind of establish this arbitration, this advisory arbitration panel, whose function then is to try to facilitate a resolution of the strike or of the dispute. And in doing so, it must issue an arbitration award, and it's not so clear exactly when the arbitration must be convened, but it must be convened with the least amount of legal formalities, and the arbitration award must be issued within 7 days after the convening of the arbitration hearing. So once an award is issued, parties then have 7 days within which to either accept or reject the award. If they reject the award, they must they must give reasons why they reject the award, and they must consult their members before rejecting the award. If they accept the award, then it has the effect of a collective of a collective agreement. Or if they don't accept the award within the 7-day period, it will be deemed as if they accepted the award. So if they agree to accept the award, then the effect really is it will bring an end to the strike, because one of the limitations of the right to strike is where a collective agreement regulates the issue in dispute, you cannot embark on strike action. So if the arbitration advisory award has the effect of an arbitration award, has the effect of a collective agreement, that will effectively bring the right to will bring the end to the right to strike in that context. And there are some academics who are of the view that this has been a very carefully crafted piece of legislation, these amendments in particular, and it's unlikely that it will curtail the right to strike. Then the last amendment I want to look at is the transitional provisions in terms of Section 19. Now, Section 19, these amendments came into effect on the 1st of January 2019, and in terms of Section 19, the registrar was required to, within 180 days, meet with trade union parties and employer organizations whose constitutions do not provide for a secret ballot in their constitutions. And if the constitutions do not provide for the secret ballot, then the registrar had to then issue a directive after consulting with those parties, really outlining a time period for the trade union party or the employer organization to comply with Section 95 of the Labor Relations Act, and in particular with the requirements dealing with ballots. Now, Section 95 it deals with a host of requirements that must be met before a trade union is registered, or before an employer organization is registered. And one of those requirements is there must be a ballot that must be conducted before a strike. Now, there has been a recent decision in the Labour Court, in the decision of Mahle Baer versus NUMSA, where the Labour Court there had to determine whether the union did not comply with the provision of Section 19. It was common cause, in fact, that they did not issue, there was no ballot that was conducted, and as I recall it, the Constitution also did not provide for a ballot. So the court had to decide whether there was sufficient grounds to interdict the strike. And what the union argued was that the transitional provisions amounted to a violation of the right to strike. And it also argued that the requirement to amend its constitution only kicks in once the registrar has made has issued a directive for the constitution to be amended. Now, the court was of the view that there was no limitation of the right to strike. The court held that all that had to be required was for the union to comply with Section 95 in relation to the ballot, which had to be conducted in secret, and there had to be a ballot conducted before the strike was called, and the court held that section was peremptory, and therefore there were grounds to interdict the strike. In terms of, the court was also alive to the ground of to Section 67(7) of the Labor Relations Act, and there it deals with a constitution that does not comply with Section 95. And in terms of Section 67(7), where a constitution does not comply with Section 95 that deals with ballots, then it doesn't prevent the strike from taking place. It's not a ground to interdict the strike. So the court held that we are not in that arena, because here we are dealing with a union whose constitution does not provide for balloting. I have some reservations whether this judgment will withstand constitutional scrutiny. If you look at the decision of Setau versus Equity Aviation in Moloto that was handed down several years ago, I just want to quote a quick passage here. the court held that the right to strike is protected as a fundamental right in the Constitution without any express limitation. Constitutional rights conferred without express limitation should not be cut down by reading implicit limitations into them, and when legislative provisions limit or intrude upon those rights, they should be interpreted in a manner least restrictive of the right in the text, if the text is reasonably capable of bearing that meaning. So I think it's arguable that there has been an implicit limitation in this, in terms of Section 19, when the court interpreted Section 19, and that might constitute an interpretation of the provision in a manner that is not least restrictive. So undoubtedly there will be case law that will deal with this issue, and it remains to be seen which way it will go, because if you go to court and if you approach a more liberal judge, I think it's going to be very difficult to convince that judge that a strike should be interdicted because there hasn't been compliance with Section 19. Thank you.
Thank you very much, Ishad. Okay, we are now at the end of the discussion, the seminar. I think you will all agree that it was quite an educational seminar. We started off by discussing some of the important changes to the new CCMA rules, touched on the controversial National Minimum Wage Act and its regulations, and some of the things that Aslam discussed that I didn't even understand or know about, which will probably have very far-reaching implications. Then Thandeka went on to discuss some of the changes in our in the parental leave and requirements that are brought about by our changing family structures. And the seminar was then concluded by a short to discuss some of the important changes to the Labour Relations Act and how they relate to picketing and striking. So we have in the program we have a moment to have questions and answers. I think obviously, like I said in the beginning, that you can speak to our professionals individually. We'll have a moment to have tea and coffee outside, but I think it's also important that if there is questions, some people might be dealing with similar challenges in their environment. So please, I encourage you now, if you have any questions that might assist us all, please, this is your moment to ask. Sure.
Maybe not related to today's content, but do you foresee any major changes coming in the temporary employment services space anytime soon?
I doubt it. I mean, there has already been significant changes, and those changes have been tested recently in the Constitutional Court. So I think it's unlikely in the current context that we will be.
Those apply to below the threshold.
That's correct.
So you don't think there's anything in the cards?
I doubt it.
And then for Thandeka, correctly, but I know that you said it's not entirely clear whether those. Do you think that the leave for the maternal period would be parallel to the maternity leave, or could you add those 10 days? What do you think?
I think the purpose of the Act was actually, because the Basic Conditions of Employment Act were more protective of maternal parents. So I think when the drafters were excluded, it could be that the maternal parents can still claim if they need additional days, depending on the circumstances of maybe the age and the way in which the child is born. Some children are born with, for example, if a premature child is born and you need more months, maybe you can still rely on the 10 days as well to take care of the child. But as it stands, my understanding is that the maternal period must rely on Section 25, which is the 4 months, and then they can't rely on the parental leave because it's essentially for those parents who cannot exercise the right until Section 25. Yeah.
Any other questions?
Will the CCMA rule changes automatically apply to marriage, cancer, dispute resolution?
No, the CCMA rules only relate to the CCMA. However, there are many bargaining councils that rely on the CCMA rules insofar as regulating the bargaining council disputes. So the bargaining council will probably need to amend its rules in order to bring it up to speed with the latest amendments to the CCMA rules. But it doesn't automatically.
Is there anything else?
When is the maternity law expected to come?
At this stage, it's unclear. As I mentioned, the hold-up is sitting at the UIF because they're still trying to get their systems in line in order to be able to take to be able to actually respond to the claims that the parents are going to be now claiming against. So they're still waiting as well. We have a National Minimum Wage Act that has come into effect. We don't know what's going to happen in the employment realm. Are employers going to be able to pay the 20 rands? So what's going to happen? Are people going to get retrenched? So I think the UIF is just waiting to see how the National Minimum Wage Act is also going to pay out, and once that is settled and employers are actually understanding and started implementing that, then they're going to start also trying to now accommodate the parental leave, and then it will start to come into effect. But right now it's still unclear when it will come, but it's still an act, and nothing's going to change in the act. It's just that the date hasn't been confirmed by the president. No,
the
so
employer will be charged on how he's dealing with the maternity leave.
So what I was basically saying is that if an employer is currently providing for paid maternity leave in the workplace, if an employee now comes and then wants to take paternity leave or wants to take parental leave or commissioning parental leave, and then you do not provide them with that same benefit, at the end of the day, we're looking at the best interest of the child. What is the purpose of the leave? The purpose of the leave is for the newly born child to be able to adapt to the new environment, not only for the mother or the father to be able to bond with the child, but also to take care of the newly born child. So now, if you're looking at it from that context, you need to provide, because when a person is away from work and they're not getting paid leave, there's already negative stringent effects, because now you need to take care of this newly born child. So now, if you're providing that to the maternal parent, why would you not provide it to these other parents as well? So just to avoid that, because employees will look at it from that perspective, that you providing maternity benefits, you're not providing with the same maternity benefit, but the effect is still the same, that we are taking care of this newly born child. So it will be better so that we can avoid unfair labor practice referrals to the CCMA, and yeah.
Buti.
I'm directing the opportunity, Richard, on the issue of national minimum wage. You indicated that you cannot pay independent contractors the minimum wage. Now, I'm going to show if I understand the is correctly, because in my understanding, the independent contractor provides the service, and in return, will charge for the service. Now, the issue of minimum wage, I'm not sure how it gets in, unless if you independent contractors agreement, which I want to talk about.
If you look at the definition, right, it's general independent contractors. If it's a company, if it's a company that's providing the services, you are generally paying the company that's providing the services directly, as opposed to the person that's providing the service. But when it comes to self-employed independent contractors that don't belong to a company, in those instances, I understand what you're trying to say is that they generally charge you not per hour, they charge you for, they come in 2 hours to fix, for example, electrical work. Somebody might come in and they charge us 5,000, it takes 3 hours. But at the end of the day, it's self-employed. It's a gentleman that, or a person that doesn't belong to a company that's providing the service. When he comes out and does what he's required to do, at the end, the hours that he has spent providing that service, you cannot pay less than the minimum wage. And that person, how it's going to pay out, it depends. Can that person then say that I've worked or provided a service to company A, B, and C. I did work for 3 hours. They paid me 50 rand for the 3 hours. Can he then approach the CCMA and lodge a dispute against company A, B, and C for non-compliance? How it would work would depend, because he's not only going to be providing the service to you. Can we then have a self-employed independent contractor referring disputes against company A, B, and C, D, E, F? So he could have 8 or 9 claims against different companies that he's providing the service to. So it will have to see, we have to see how it turns out at the CCMA when they are approaching something. But as it stands on the narrow meaning or the broad meaning, includes independent contractors who are self-employed. It will be difficult to include independent contractors who are companies on their own, because you are then not paying the employee that's doing the work, or the independent contractor comes out the site. You are paying the company that employs him. So in that situation, I don't think the single self-employed, how it pans out.
Sorry.
So for secret ballot, must that be done before the strike?
Well, look, it's not entirely clear. It's arguable in terms of this judgment that a secret ballot must be conducted. It leaves the basis of the initiative. We're dealing with the transition provision. It was still within the 180-day time period. There was no directive that was issued compelling the trade union to amend its constitution. But it's arguable that, notwithstanding there was no directive, trade unions are nevertheless obliged to amend their constitution to bring it in line with Section 25 because of the judgment. So it is arguable. It really is uncertain terrain, and I think you can see a lot of attempts made by employers to interdict strikes, and it's going to be very interesting times to see how it all turns out, or how it turns out in the report.
Any other questions? Just at the back.
Thank you. My name is Harry Knox, and my question pertains to the parental leave. And I guess that my question goes more to the point of in circumstances where there's a surrogacy agreement or adoption, and you mentioned in your presentation that the Act provides for relying on the honesty of the employees, but typically the parents will work for different employers. And we all know that employees aren't always as honest as we'd like them to be, especially when it comes to issues of leave, especially with sick leave. So I was just wondering, when you were talking about whether the Act gives an employer any recourse to establish or get disclosure of what leave has been applied for by the other parent, so that both parents don't abuse and apply for the longer leave.
Yeah. Unfortunately, the Act is not clear on that. How can the employers protect themselves from employees not being honest about that? But that's why it places it on the employee to be the one who's actually honest to the employer. But in an instance where, for example, the leave is unpaid, they're going to be claiming that amount from the UIF, requesting the UIF to pay this amount of leave. So I think that's the one reason that the UIF also has not actually, the systems are still not ready, because they need to now, as the regulators of the fund, they need to now make sure that they're not paying people like another person taking 10 consecutive weeks and another at the same parent is also taking 10 consecutive weeks. They need to have a system that they're going to be able to check if the employee, if they're being honest in terms of the provisos of the Act. So I think that is the one reason as well that the UIF Act has not, and the systems are still being updated. But now, if an employee is dishonest in relation to that, we can always take disciplinary action, because there is a duty on an employee to be honest with an employer. So if you do not do that, then you must provide in your disciplinary codes that if you are dishonest in relation to these kinds of leave entitlements, then we have a right to institute disciplinary action against you.
What about ascertaining whether the father is the father?
That's a different one. Is that in relation to the parental leave? Well, I've never had a child, so maybe other people can be able to explain, but my understanding is that if the person is applying for this form of leave, they'll have to come with a birth certificate which has, if it's unabridged, it will have the details of the father. So if you don't have those details, it's going to be quite difficult for you to say, I'm the father. And that's the reason why the Department of Home Affairs requires that the mother and the father must be registered as the parents of the child. So if they don't have that, then not the way they were when the child was being born.
Yeah. But sorry, I'll give a false
So it might not be the biological parent, but it might be
To the adoption process.
well, not necessarily. If the mother has married this guy or she's had an affair, but this one is going to take the responsibility. We have very much weird situations in South Africa. But so I'm just saying that if this person is taking the role or responsibility of the primary caregiver, then it's irrelevant. You know,
Yeah, it's going to be very difficult to regulate, unfortunately.
But that would relate to the parental leave, not your commissioning leave, not your adoption. And is parental leave only for a parent or for a caregiver? What is the purpose for parental leave? That's what we're going to see. If he is not the real father, but he is the caregiver, he is going to be taking care of the child together with the mother of the child. He then would qualify for the parental leave because it's for him to bond with the child. That's the purpose of it. So I think under those circumstances, you would be allowed to do that.
Yes, we also have situations where other family members are the primary caregivers of this child and not the biological parents.
Like grandparents.
Like grandparents or aunts or uncles. So it becomes a little bit...
I think, I understand where you're coming from. I think it might be regulated in some way. There might be regulations that would accompany the schools or some kind of proof that is required. What is per se a caregiver? When do you qualify for a caregiver? And those kind of stuff. Like the minister might have to publish some regulations to do and how
Any other questions? Yeah, so this is definitely a very interesting discussion. What is quite clear from this is that everything is quite new right now. Everything that was being discussed today has probably been untested a bit, and there'll probably likely be more developments as things go on. And in that instance, our team is obviously going to be available to assist in any queries that you guys might have. Our employees are still important. I mean, we're in the world of automation, but in South African context, employees are quite important, so we understand and appreciate that, and we are there to assist you guys with any of your concerns. So, like I said earlier on, there's tea and coffee and some snacks, I think, outside. Please grab some before you run off to the offices and start getting on with your day. And our team will be available, as I said earlier, to discuss any other concerns you have in greater detail. Thank you very much, ladies and gentlemen, for joining us.